So this video is about how transfer on death, or TOD designations, and joint tenants with rights of survivorship designations are not valid for investment accounts in Louisiana. I'm Paul Rabelais. I'm an estate planning attorney in Louisiana. This comes up a lot. Everybody's confused. Give you an example. Mom and dad come in. We talk about arranging their legal affairs. They want to avoid probate, and we get to start talking about their investment accounts. And they tell me they have three. They tell me dad has a traditional IRA, mom has a traditional IRA, and they have another investment account. They say, Paul, don't worry, we got all that covered. We designated beneficiaries at XYZ financial institution. And in the back of my mind, I'm saying, you ain't got it covered, because Louisiana is very unique. We're the only state, and I'm really speaking for Louisiana here, there might be another exception or two, that doesn't allow people to designate beneficiaries on the non-IRA, non-retirement investment accounts. Yes, you can and do and always will, I suppose, designate beneficiaries on your IRAs, traditional Roth, your 401ks, your life insurance, your annuities, but many people own investment accounts that are not retirement accounts, and the family winds up having to go through probate because they think they've designated a beneficiary, but they haven't because they can't. So here in Louisiana, our laws are unique. We don't allow some of these simpler forms that other states allow. Some people think that they could, or they did, or they get caught. Tomorrow I'm starting a probate for a family where the gentleman had an IRA and an investment account. The IRA had a beneficiary, the investment account didn't, because you can't, got to go through probate if it's titled in your name when you die. So just a little backup documentation in preparation for this video. I Googled this stuff and I pulled down some of the beneficiary designation paperwork for some of the top, financial institutions in the country, and I picked the first ones that popped up. All good companies, all have recognized that in Louisiana it's different, and that you can't do things that in other states people can do. So let me go through a few of these. The first one I pulled up was the Edward Jones transfer on death agreement. So again, idea: someone has an investment account. Yes, they have beneficiaries on their IRA, but they have an investment account. They can fill out this Edward Jones transfer on death agreement. They can designate who they want that account to go to when they die. They die, probate's avoided. Edward Jones pays out the account, proceeds to whoever was designated on the transfer on death agreement. If you go to that agreement on Edward Jones, it says this agreement shall not be valid and shall be of no effect in the state of Louisiana if an account owner applies the TOD feature to his or her Edward Jones account under this agreement while a resident of a state other than Louisiana and later becomes a resident of the state of Louisiana, then this agreement shall be void at such time as the account owner becomes a resident of the state of Louisiana. First sentence is the one that's most applicable. This agreement shall not be valid and shall be of no effect in the state of Louisiana. Can't do it. Go to my next one. I go to Merrill Lynch. I go to their joint account agreement, and the Merrill Lynch joint account agreement, where people often designate their account, particularly when you have married couples. You can check off whether you want to designate that account as joint tenants with rights of survivorship, which means if one owner dies, his or her interest passes to the other owner or the surviving owner. Real simple, all goes out of probate, but Merrill Lynch form accurately states that under the joint tenancy with right of survivorship option, they put in parentheses, not available for Louisiana residents. Go to another Merrill Lynch form, the transfer on death agreement, similar to Edward Jones. Their Merrill Lynch transfer on death agreement says, notice, transfer on death accounts are available to account owners who reside in all states within the United States other than Louisiana. Aren't we special? So again, not recognized in Louisiana. Go to a couple more. Next one is our JTWROS transfer on death agreement, another good company under the TOD information on the JTWROS transfer on death agreement. It says TOD, transfer on death. TOD is not recognized by the state of Louisiana, so we do not offer TOD for Louisiana residents. Last one, just a little bonus, is Charles Schwab, another good company, very popular. In their designated beneficiary plan agreement, And again, where people on non-retirement accounts can designate beneficiaries, it's all in the the thought is simplify it for people to set up their accounts so they don't have to go through governmental bureaucracy, judicial proceedings just to get at an account. The Charles Schwab Designated Beneficiary Plan Agreement says this plan is not available in Louisiana. So there you have it. There's, I could probably find this for every company. Some of the smaller companies out there don't do it, and maybe they all do now. But if you live in Louisiana and they let you sign one of these agreements and then you die, they're not going to release the funds once they find out that you lived in Louisiana, because they're going to risk having to release those funds to those TOD beneficiaries and then ultimately being responsible to the estate's heirs or the living trust beneficiaries. And so they'd have to pay twice. They don't want to do that. Okay, so the real solution, if for people who really want to simplify and make it easy for their loved ones to get those assets when they die without having to go through lawyers and courts and judges and incurring significant expenses and delays and just hassle, is to set up that revocable living trust, title your investment account in the name of your trust. You're the trustee as long as you're alive. Whenever you pass away, you will have named a successor trustee in your trust instrument who will have immediate access to the trust account and be able to disperse the account assets or the account holdings to the beneficiaries that are designated in the trust instrument. If you leave those accounts in your name, they're going to be frozen when you die. Nobody's going to have access to it. They're going to have to come back to me or somebody like me. I'd love to meet them, but a lot of families don't want their survivors to have to go through that. Okay, one more related point has to do with something called POD. We've been talking about TOD, transfer on death, not recognized. We've been talking about joint tenants with rights of survivorship, not recognized in Louisiana. POD is something just for banks. They put something in our banking laws in Louisiana years ago, and it's kind of tricky. So I want to pop that one up because I want to, again, get it just right. And so what the POD banking laws do is at some banks, they let you go to the bank and sign some paperwork designating who your bank account is payable to when you die. Easy enough. You die, they produce a death certificate, bank releases the funds, no probate, no lawyers. However, that POD law is just in our banking regulations, and all the POD law does is it relieves the banks from liability to the extent that they release those funds to the POD beneficiaries. It doesn't say anywhere in our inheritance law or succession law that those POD beneficiaries become the owners. So there could be a unique circumstance where mom designated some people on the POD designation, but in her will or trust, she designated her estate to go to others. Those people who got the money on the POD designation may be accountable to the heirs of mom's estate. So you want to make sure all that stuff's consistent. But all the POD, one statute in our banking law that says if a bank, pays money to POD designation people, then the bank shall not be liable to the estate or any heir of the decedent. So it relieves the bank from liability. Just be aware that that exists. Okay, so there you have it. Really important. Don't just assume because you designated beneficiaries on your IRAs at the investment firm or the financial institution that those beneficiary designations also apply to your non-IRA accounts. They don't. So you've got to address how you'll be leaving those behind differently than you do your IRAs. Often overlooked, often people assume the wrong things, but the people who understand this stuff address it the right way, get it right. If you want to find out more, subscribe to the YouTube channel. Go listen to our podcast. We have one on this topic, Estate Planning with Paul Rabelais. Check out our website where we post more information on the website, RabelaisEstatePlanning.com. Also a list of other upcoming live events where we talk about how to protect what you have. I'm Paul Rabelais. Go Tigers. Have a great day.